Henry.
Welcome everyone to the League of Women Voters Moscow Speaker Series. We're really excited about this week's presentation. Our talk today will be on the legal ramifications in Idaho of overturning Roe v. Wade. We are really honored today to be joined by Professor Shaakirrah Sanders. She is the first Black African American to earn the rank of full professor at the University of Idaho and its College of Law. She teaches, writes, and comments on U.S. constitutional law and criminal procedure, including the First, Fourth, Fifth, Sixth, and 14th Amendments. During the 2022 to 2023 academic year, Professor Sanders is visiting the Penn State Dickinson School of Law, which is great for us to be able to do a Zoom event and have her here with us today. Professor Sanders is a contributor for SCOTUS blog and regularly sought to share commentary on current events related to constitutional law and the US Supreme Court. She has appeared in a number of international and national news publications and broadcasts, including CBC News Network, Politics Nation, Simone, Now Tonight with Joshua Johnson, the New York Times, the Washington Post, the Associated Press, BuzzFeed, Glamour Magazine, Yahoo News, and All Things Considered. Professor Sanders also regularly appears on television and radio news broadcasts in Idaho and the Pacific Northwest. And we're really excited that she is able to join us today for this discussion. So our plan is that Professor Sanders will present on this topic for about 20 to 25 minutes, and then we are expecting a lot of questions. So for our Q&A session after the talk, please feel free to put your questions in the chat and we'll help moderate. And if you want to unmute yourself and ask the question aloud, we ask that you use the raise hand function on Zoom so that we can call on people and make sure we get the questions answered throughout the session. So with that, I will turn it over to Professor Sanders.
Good afternoon. Thank you so much, Kylie, for such a wonderful introduction. And I'd like to thank the Moscow League of Women's Voters for the invitation to join you today. It has been some time since I have lived up in Moscow and have had a chance to talk with you guys. So it's always a nice feeling to be able to return and work with some of the organizations that I became familiar with when I first joined the university and I was teaching up in Moscow. I just want to start this conversation by acknowledging just how incredibly difficult of a moment we find ourselves in with regards to the constitutional protection for the right to terminate a pregnancy. And at this point, there is a lack of federal constitutional protection. As stated, my hope is to speak for about 20 to 25 minutes so that we can have as much time as we need for Q&A. If you, however, have a question prior to the end of my remarks, don't hesitate to use the hand raise function on Zoom. I have returned to the classroom for the first time in several years due to COVID, so I've become quite good on catching those hands on Zoom. And at this point, I think I may be slightly a better Zoom teacher than I am a physical teacher. Either way, I just want to again say, I acknowledge how difficult of a decision this is to digest. I will confess that I had been in a fair amount of denial that this was going to happen, even though all of the signs were pointing in that direction. I have yet to teach this material this semester in constitutional law, and I am very, very nervous about doing so. This is unprecedented to the extent that a federal constitutional right has been rescinded. It is not clear to me whether the US Supreme Court has rescinded wholesale a right in the past, although I have been trying to remind people that if you look at criminal procedure jurisprudence, there certainly has been a lot of chipping away at constitutional rights in a way that are just as concerning. I want to focus today on the Dobbs case, which overturned Roe versus Wade and Planned Parenthood versus Casey. But before I get to that case, I just want to remind us of Roe versus Wade and Planned Parenthood versus Casey. So Roe versus Wade was a early 70s decision. It declared that there was a federal constitutional right to terminate a pregnancy. The source of that federal constitutional right lies in the right to privacy and substantive due process. I always note that Roe was not a case about gender classifications or gender discrimination. The court really focused on the history and tradition of the right to terminate a pregnancy. The court begins its decision by talking about ancient Persia, ancient Roman law, fast forwarding to the English common law. A very curious lack of conversation about US colonial practices, particularly the treatment of enslaved and Native American women, but to the extent that the court's original Roe decision acknowledged that there was a history and tradition of allowing a limited right to terminate a pregnancy. That's what we got from that decision. Roe set up a trimester framework for analyzing when the right applied. Under Roe, in that first trimester, the abortion decision was originally between the patient and the doctor. During the second trimester, the regulations really had to be targeted towards the mother's health. And in that third trimester, the court has always said that there was a right to ban the procedure, except for cases of health of the pregnant person. So 2 decades after Roe versus Wade, we got the Planned Parenthood versus Casey decision. Now, Casey upholds the right to terminate a pregnancy, but it does create a new framework for analysis. There, the court says, instead of a trimester framework, we're going to go to a viability framework. Now, curiously, Casey made clear that even prior to viability, there was a profound interest in the fetal life that the state could protect. That was a huge shift from Roe versus Wade and really opened the door to a lot of the type of regulations we saw after Planned Parenthood versus Casey, all of which I think sort of culminates in the Dobbs decision. The Planned Parenthood versus Casey case also imposed an undue burden standard on the right to terminate a pregnancy. There, the court explained it in a way where if a regulation would prevent a substantial obstacle for pregnant people, then it would be deemed an undue burden. But we also saw in subsequent case law, the court making clear that unnecessary regulations will be deemed to be an undue burden as well. But despite those changes with Casey, the court still upheld the basic right to terminate a pregnancy, made it clear that prior to viability, abortions could not be prohibited. Casey and Roe agreed, however, that in that third trimester or post-viability, there was always a compelling interest on the part of states to ban pregnancies. Now, of course, we know that even after, or even with the existence of Planned Parenthood versus Casey and Roe versus Wade, we didn't have a situation in the United States where abortions were equally available to individuals. There's tons of empirical evidence that individuals with low economic status, individuals who are living in rural areas of the United States, States, as well as many women of color, really lacked access to safe abortions. And I say that so that we remember, right, that this was not a right that was as widely available as we like to have thought. In fact, I still find it shocking that 2 years ago, when the court was looking at the whole women's health case, we were dealing with a situation, a case out of Texas where there were no clinics in West Texas, right? And you can, according to some people, I've never really driven through Texas, but apparently you could drive days in West Texas and still be in Texas, right? But yet that is a significant portion of one state that really lacked access. Of course, those of us in Idaho also know how little access there was to this right. So we come to Dobbs versus Jackson Women's Health, a case that has declared that there is no federal constitutional protection for the right to terminate a pregnancy. A case that made the decision outside of the context of gender, outside the context of socioeconomic status, and an opinion that, like its originator, Roe versus Wade, focuses very much on the history and tradition of the right to terminate a pregnancy. As I stated at the beginning, am still processing this entire issue, still processing the decision itself. I want to make clear that I will not be providing any nuggets of wisdom to help people understand this decision because for me, given our continued inability to really look at this as an issue of socioeconomic status that intersects with gender and race, I just don't think it's really possible for me to sort of explain this decision in a way that makes sense. And not just because I disagree with it, but I will say that it is personally a difficult decision to talk about. Instead, what I like to do is focus more on the challenges to Idaho's laws surrounding the right to terminate a pregnancy, particularly 18-622 of the Idaho Code, which is known as Idaho's trigger law. This is a law that created the crime of criminal abortion. This is a crime that anyone can be charged with if you have aided or abetted an individual who wishes to obtain an abortion. This is a law that applies to doctors, medical personnel, and some have even argued people who drive an individual to a clinic to receive that type of medical treatment. 18-622 of the Idaho Code allows abortion where it is necessary to prevent death and in cases of rape or incest, but only where an individual has previously reported the rape or incest. Now, with regards to the first opportunity or this first exception to prevent death, I very much note that it speaks nothing of life. I very much note that it does not speak to, it doesn't speak to the health of the pregnant person. It is very unclear to me sort of how close to death does one have to be before an abortion can be obtained. And I'll talk about the type of legal challenges that we have seen and that we'll continue to see over that issue. The second exception in cases where rape and incest is reported. I note that a very similar provision was analyzed in the Planned Parenthood versus Casey case. That case was not just about whether or not Roe versus Wade should be upheld. It also dealt with waiting periods and a very similar provision that dealt with a spousal notification, where in Pennsylvania's law, there was a similar exception for rape and incest where it was reported. I bring that up because Justice O'Connor and the majority in Planned Parenthood versus Casey found that an exception that requires an individual to report rape or incest is really insufficient to protect an individual who is seeking to terminate a pregnancy. The court pointed out all of the issues that arise for victims of abuse, sexual abuse in particular, the fact that once you report, the abuser is given notice of that report, an investigation begins, and that could lead to a very dangerous situation for the individual who is pregnant. So it's a little bit unclear how that reasoning holds up post-Dobbs. Either way, the Dobbs decision, which was decided in June of this past year, made clear that there is a new majority of the U.S. Supreme Court, that they disagree with the Roe versus Wade analysis of the history and tradition with regards to the right to terminate a pregnancy. The Dobbs court made clear that because of this continuing controversy surrounding Roe versus Wade, that there could be no history or tradition that supports the right. Dobbs put it in the hands of state governments to decide within their jurisdictions whether this right exists and what is the scope of the right if it does exist. Dobbs has made it clear that the federal court no longer upholds Roe versus Wade and Planned Parenthood versus Casey, and that both cases are overturned. Now, again, Dobbs was not a decision that focused on gender issues, the type of racial disparities that exist. Nor did Dobbs, in its foray into history and tradition, have any conversation about the treatment of enslaved women who had no control over their reproductive health, and many of whom were subject to forced abortions. Nor did Dobbs address the treatment in terms of history and tradition of Native American women, many of whom we know also faced atrocities with regards to their reproductive health and even custody of their children once they were born, much like enslaved women. And so I always like to note the ways in which our jurisprudence, while it may come to a different conclusion, uses the same process. So turning our attention to Idaho's trigger law, which bans the procedure except in very narrow circumstances. We've got one challenge to this law that has been brought in state court by Planned Parenthood and others. Last month in August, a little over a month ago, in fact, there was oral argument in our state Supreme Court, and we had a 3-2 decision that chose to deny a stay of enforcement of Idaho's new abortion law. So one thing to understand is that the Idaho Supreme Court's decision is not the final decision. It's really about whether or not the law can go forward while the constitutionality is further debated. But that opinion did read very much as if there was a majority of the Idaho Supreme Court that would deny a right to terminate a pregnancy. Some of that, of course, is based on Idaho's law prior to Roe versus Wade, which banned the procedure in the state. A lot of it also had to do with the court's reading of privacy rights under the state constitution. The more intriguing case at this point, especially if you are an advocate of the right to terminate a pregnancy, is the case brought by the U.S. Department of Justice. The U.S. Department of Justice has recently received a stay by Justice Windmill in federal district court on the grounds that Idaho's law may be preempted, or portions of Idaho's law may be preempted by federal law. So I will tell you, there are a number of federal regulations regulating doctors and hospitals that receive federal funds. One of these laws talks about how abortions must be provided to protect a woman's health. And if you, as you can understand, an Idaho law that applies only to prevent death quite possibly poses a conflict with a federal law that requires doctors to protect health and life. So that is a lot of the crux of the federal lawsuit brought by the Department of Justice. They have argued that hospitals and providers in Idaho that receive federal dollars must follow federal law under the U.S. Constitution's Supremacy Clause. The Supremacy Clause states that federal laws and our federal constitutions trump over state laws and state court decisions. And so the Department of Justice argues that Idaho's law conflicts because it only protects life, and federal law includes life and health. As I stated, there is a stay in place in federal district court that prevents part of Idaho's law from going into effect, to the extent that it orders doctors to perform abortions only in the case of life or where life is at risk, and to the extent that hospitals, right, are grappling with this Idaho law. Now, it is not clear to me whether the state of Idaho will be allowed, or any other state agencies, who's going to be able, I should say, to intervene in this federal lawsuit. It was certainly something the Idaho statute raised my eyebrows, to the extent that it only allowed an abortion where one's life was at risk as opposed to one's health. It is unclear to me whether we will see other lawsuits on other grounds. Again, this idea that you can only have a medical procedure if your life is at risk could implicate substantive due process, this idea that we have a right to life and liberty. But I also note that health has never been declared to be a fundamental right or especially protected. And so we could see in some of these cases other issues being raised that go to really serious questions that have never been answered. I also do wonder, and this may not be something, well, I should say what we've also seen is the federal government making several pronouncements about the availability of abortion at, say, like veterans clinics and other things. So it's unclear to me whether we're going to see more lawsuits in Idaho, considering the presence, the military presence in the state. It is unclear to me whether we may see more litigation. I would not be surprised if there is additional litigation over the availability of certain procedures. And I wouldn't be surprised if it's the state of Idaho suing the federal government over the availability of certain procedures in federal hospitals. Finally, I do just want to more directly address the issues of disparity. Because I think that that is a really important issue. To the extent that there may or may not be this very narrow, limited right to terminate a pregnancy in Idaho, I'm not sure how long this is going to maintain. As disappointed as I am with the Dobbs decision on a personal level and an intellectual and academic level, I remain hopeful that we'll get a better Roe versus Wade decision in the future. that we'll get a decision that is more inclusive of the experiences of all pregnant persons in our country. A decision that is more honest about the history and tradition of the treatment of all pregnant women in our country. And that more inclusive decision will equate to a more strongly protected right. I think some of these gaps in care that we have accepted, our collective we have accepted over time, has made this right completely vulnerable, never really secure. And I think with a stronger decision that is more inclusive, perhaps we can avoid the constant attacks on this right when we see that it returns. Because to make clear, part of what we must also understand is that decisions like this are reflective of the lack of diversity in the legal profession. Think about the people who make the arguments, the people who wrote the decision in this case, right? We only had one more woman in the majority in Dobbs than we had in Roe versus Wade, and we didn't have any women on the court in the time of Roe. And so for me, much of this decision is about about elements of our legal profession, about the type of diversity and inclusiveness that we should continue to strive for in our legal profession. And I say this because I was asked, right, who's going to be litigating this issue? And I pointed out that, well, we have a study of the legal profession in Idaho that shows a great deal of discrimination amongst women, right? And so how does this work when we see jurisprudence that many of us may feel don't speak to us about the gender realities of pregnancy and being argued and litigated in a profession that is not as inclusive as it should be? And so for me, there is very much of an interconnectedness with regards to this opinion and the profession that I am proud to be a member of. So that was a little bit of a detour there, but to say that we must understand the interconnectedness of many of these issues, because I certainly had a student ask me, right? How is it that we could be so far away from Roe versus Wade, and yet we don't see more than one woman in the majority in Roe, in the Dobbs case? How much change has there really been in our profession? Who gets to be in the seat to make the decision? I reminded the student that while we only had one woman in the majority in that decision, we all are very soon at, we have 4 women on the court moving forward. And that is the type of change that we need to continue to see, more diversity at every levels of our legal system, including who is in the State House debating these issues and writing these laws. And that's why I think it's so wonderful and so important for the League of Women Voters to cover this issue. I am so honored that you asked me here today, and I hope that there are many questions for me. And if there are questions, I'd like to start answering them and having the discussion. So thank you very much.
There is a question in the chat. When or how do the privacy or security laws, whoops, I've lost it, just a minute. When or how do the privacy or security laws with medical information come in? If allegations or prosecutions come from privileged medical information, are the repercussions?
Yeah, that is such a good question, right? That brings in so many different areas of the law. rules about procedure, rules about evidence, and that is certainly pertinent to 18622 in terms of proving that someone provided an abortion in violation of this criminal statute. But it is also important for purposes of Idaho's civil statute, which allows private individuals to sue individuals who provide abortions. And that is a question I've been having, right? Who's going to be allowed to have access to the information, the private medical information that is going to be needed for these civil cases, if we should see any, and for this criminal case? In general, medical information is protected by patient-doctor confidentiality. And even in criminal cases, I believe that privilege still applies. And so are we genuinely thinking about some exception to the doctor-patient confidentiality relationship that's going to apply in this context? And if so, then we really are going to have to get frank about the type of privacy protections that pregnant persons who are primarily identifying as women are going to lack. And so I'm just not really quite sure what or where the end game is here with regards to now criminalizing medical decisions. Finally, I think for Idaho, this issue is sort of slowly colliding with the faith healing issue in my mind, right? On the one hand, Idaho says you don't have to get medical treatment for your children if you want to solely rely on faith. On the other hand, Idaho is saying we care so much about children, right, that you can't terminate a pregnancy. Well, I think Idaho's going to have trouble with its profound interest in fetal life if in one situation you're allowing people to forego any type of medical care, right, regardless of what may cause the potential injury to the fetus, whether it's abuse, right, whether it's you're not eating right. In one context, if you claim a religious practice, you're good. But in a whole nother context, regardless of the health implications to you, you could be forced to give birth, right? And that could cause your death, or you could be forced to carry a pregnancy, even if it results in rape or incest. So I think at some point, some meaningful frameworks are going to have to take shape in the state to, one, protect privacy, but two, to allow sort of equality with regards to the treatment of fetuses.
Thank you. So we have some hands up, and then we also have some questions in the chat, but the hands went up first. So Zena, why don't you go ahead?
First, thank you so much for joining us today, Shaakirrah, Dr. Emil, Sanders. Okay, let me center myself so I can speak correctly. My concern came when you were mentioning the overturning of Roe v. Wade, because the decision was based on privacy. So I would like it if you could speak more to the question of privacy, particularly because for me, this decision wipes out a sense I've had since childhood, that I had a measure of bodily autonomy that gave me my place in society was protected because it was my body, I could make my decisions. So that one seems to hang for me as now very much in question. So, and according to what I heard from you, that privacy was one of the bases of Roe v. Wade. So if you could speak to that, please.
Thank you for that question. I've gotten that a lot. It's something I've been thinking about, right? When we talk about history and tradition, well, I was born after Roe, so all of my history and all of my tradition points to the availability of exercising this right, right? So a lot of that is about who's making this decision, who's looking at history. But yes, the original Roe decision was based on privacy. It was an extension of a case called Griswold versus Connecticut, which was a mid-1960s case, or maybe late 1960s case, regarding the availability of contraceptives for married persons. Now, in that case, Connecticut had decided that married people could not use or get access to contraceptives. Their goal was to prevent infidelity. Which always blows my mind, right? When you think about the type of laws that were in place back then. But either way, Connecticut said, we want to prevent infidelity, so no contraceptives. Presumptively, I guess, they thought that if you could get a person pregnant, you wouldn't cheat on them. We all know that that was not a very well-reasoned idea. But what you got from the Griswold case was the first federal court to declare that there is a federal constitutional right to privacy. Now, privacy had been protected as a matter of state law since 1905. Georgia was the first case to decide that there was a right of privacy under state law. But it took another 60 years for the US Supreme Court to recognize that the federal Constitution guaranteed privacy. And you had a case that I tell my students, it's my favorite theoretical case that we're going to read all semester. There is a theory that Justice Douglas devised. It still holds today. He begins by telling us that privacy is older than the Bill of Rights itself. He looks to a certain amendments under our Bill of Rights, particularly the First Amendment, which protects freedom of speech and religious freedom. Our Third Amendment, which prohibits the government from forcing us to quarter soldiers in our home. Our Fourth Amendment, which guarantees a right against unreasonable search and seizure. Our Fifth Amendment, right against self-incrimination. And what he says is that if you look at all of these amendments, they create these, what he calls penumbras of privacy, or these zones of privacy, right? This idea that you can't be forced to disclose incriminating information. The idea that the Fourth Amendment and the Third Amendment protects you in your home, right? The idea that the First Amendment, there's a privacy aspect of choosing your religion, choosing to speak. Either way, you look at all of these amendments, and underlying each one is this idea that there's privacy. So he says, privacy is not specifically mentioned in our Constitution, but our Ninth Amendment says that just because you're not mentioned doesn't mean you're not part of the crew in terms of protected rights. And so he says, we believe that if we look at our constitutional scheme with regards to Bill of Rights, we find that the use of contraceptives between married persons is a matter of privacy, and that the state of Connecticut cannot intrude on the privacy that married persons enjoy. Now, let me make clear that much of that case was dealing with a married couple, and it had been very well accepted that there is a fair amount of privacy within marriage. Much of that, yes, is based on antiquated gender issue things, right? About the type of dominion a man needs to have over his wife and family. Either way, privacy had kind of been accepted as this unspoken thing within a family. And so for the court in Griswold, that was a case that very much centered on this marital couple. If a married couple wants to choose to procreate, that's their decision, not the decision of the state. If a married couple chooses not to procreate, that is their decision, not the decision of the state. Now, a few years after Griswold, we got a case called Einstein. That was a case where a single person challenged the inability to use contraceptives, because even after Griswold, states still said that single people could not use contraceptives. Now, the rationale for those laws is that we didn't want people fornicating outside of marriage. And so the way to do that, I guess, was to prevent them from using contraceptives. And there, what the court did, in its opinion, is change Griswold to say, well, Griswold, yes, it was about married people, right? It was about privacy. But the court says the right to use or not use contraceptives is really about reproductive autonomy, right? And so we had a shift from Griswold to Einstein, where the underlying rationale is, yes, still privacy, right? But it's about privacy, how privacy protects reproductive autonomy. And a single person should have the right to use contraceptives just as much as a married couple. So Einstein comes just a few years before Roe. And I think the reframing of this right to contraceptives to be one of reproductive autonomy sort of lays the groundwork for Roe versus Wade. Now, I'm also going to say that part of the reason why I don't think Roe focused on gender is because at that time, we did not have any gender cases. We did not have intermediate scrutiny. We were in a very primitive era of equal protection as it applies to gender. In fact, the first equal protection case that applied to gender was Reed versus Reed, which was decided in the same year or the next year after Roe. So our gender jurisprudence really wasn't very well developed at the time of Roe. And I think that's part of why we don't see Roe as a gender case in the majority. One of the concurring opinions actually did very much set Roe as a gender issue. And so a little bit of constitutional history there. I hope that was a helpful answer to your question.
Wow. Yeah, thank you. All right, we have Ginger. Ginger.
Hi, Professor Sanders. Thank you so much. I would like to ask two questions, actually. One of them, again, is about the 18622, the trigger law that you talked about. I'm a state employee. I very much know exactly what the lane is for state employees, but as a private citizen, I'm trying to understand how this might impact me. You gave the example of maybe somebody that drives somebody to a clinic could be prosecuted. What if I write a check to Planned Parenthood in Oregon? I'm really trying to wrap my mind around my sort of personal freedom here to do things that and support causes that perhaps I believe in. I'm wondering if you can comment on that. And then I have one more question. I was trying to remember who it was. It is this Lindsey Graham guy from South Carolina. I believe he is trying to propose a nationwide abortion ban, if I'm reading the headlines correctly. I've not actually read those articles. I suppose that's something that could happen, a law that could be. I wonder if you could maybe speak to that or what that could look like or might look like potentially. Thank you.
Yeah, so I'll do the second one first because I think that one may be a little bit quicker. It is unclear to me if there's no federal constitutional right to terminate a pregnancy. It's not really clear to me what Congress can or cannot do in terms of banning the procedure, right? So I'm not really sure how that can happen at a national level when the US Supreme Court said it's a state issue, right? So there can't be a supremacy clause, I think, that would apply if the court has said this is not the business of the federal government to the extent that there's not a federal constitutional right. And if there's a right, it's got to be under state constitutions. I don't know if the federal Congress, right, can then interfere with the national federal law when the court has said this is an issue for states. And I would suspect that if Congress did try to interfere, it would be under its commerce power. And that jurisprudence is not very favorable to the federal government right now. Now to your first issue. What about those who would wish to advocate, right? What about those who wish to support? What about those who wish to, you want to set up a nonprofit to give people rides to Seattle, right? For purposes of obtaining abortion. Can these laws reach so far as to prosecute those activities? Well, I think this is going to be, and if we find potential prosecutions, I suspect that some of these issues are going to lie under the First Amendment, right? As the court has told us, money is speech. And so I think that you should be able to put your money in political advocacy in that way. Now, if it seems like I am trying to use cases that people have maybe complained about for a good purpose, it's because I am, right? So to the extent that this is a political issue, right, that people want to engage in political advocacy, that means spending money, having a PAC, right, providing services. Well, the court has made clear that unless that you've got to have a really good reason to criminalize speech and advocacy. And it can't just be as easy as saying, well, abortion's illegal, so there's no protection for your speech on the subject or your advocacy on the subject. Now, I tell people the Supreme Court can do whatever they want to do. I am not on the text message chain for the justices. So if they want to change the law to say that there is no speech rights for this, they can. But as far as where the law is now, I think that much of the advocacy is going to be protected under freedom of speech, freedom of association, your free right to assemble, to protest your government, right, for redress of your grievances. I don't think there's going to be an ability for a state to criminally charge someone for activities in another state if that activity is legal in that state. I think if Idaho wants to target out-of-state abortions, they could have issues if they also don't begin to target out-of-state prostitution, out-of-state marijuana sales, right? Things that they've said that they're not really going to prioritize, right? Idaho State Police. And so you could see an equal protection issue that surrounds the state's enforcement of its own laws, the targeting of certain politically unpopular behavior could be what puts Idaho on the wrong side of this. And to me, that's something I'm certainly watching. What is the state's reaction going to be? I don't know if they're going to have jurisdiction to go into another state, right? But if they want to sort of attempt this, I think that it will provide an opportunity to really show the type of disparate law enforcement that exists in the state of Idaho. And that may bring the type of attention that the state really does not want. So I hope that was a helpful answer to your second question. I've been getting a lot of that, right? What if I want to help someone? What if I know someone? We've certainly seen in the aftermath of Dobbs, the case out of the Midwest in Ohio, where you had a 10-year-old rape victim who the doctor had been threatened with criminal prosecution because she was trying to find an abortion provider in another state, right? I don't think these are hypothetical issues, but I also think we've seen a different political blowback, right, on the harshness of some of these laws. I don't discount that political response as well.
All right, thank you. Professor Sanders, we do have a few questions in the chat, and let me get to those. Okay. HIPAA at a federal level trumps Idaho state law about investigating if a person has an abortion. That's a question.
Yeah.
So it does. Yeah.
Yeah, so I think this gets to the Idaho law surrounding, and I'm sorry, I should have discussed this law, the civil sort of claim that Idaho has created for family members of the aborted fetus. I'll put it that way, right? And it is really strange how you are going to get information from doctors, from providers, without violating a number of federal laws about medical privacy. Moreover, I've been reading a lot about these apps out here, right? You've got apps to help you keep track of ovulation, all of these things. It is unclear to me how law enforcement is going to get into someone's phone unless they get a warrant, of course, right? And it's unclear to me what judge is going to have the stomach to issue a warrant for something like this, right? And if we start to talk about laws that are primarily going to target women, right? And here, and like I said, most pregnant people identify as women. And so how are we going to deal with the potential gender disparities that could result from many of these laws? And Idaho being what it is, I would suspect that within that gender disparity, there's a fair amount of racial disparity as well. And finally, we know that those who are going to be most vulnerable, regardless of your race or gender, are going to be poor people. I make enough money where should I find myself in that unfortunate circumstance where I have to terminate a pregnancy, I know I can get a plane ticket and get out of Idaho, right? But that is not the case for the vast majority of people in the state. And so how do we deal with this in a state that already has a low quality of healthcare even more? Are we going to see studies in our state about healthcare outcomes with childbirth versus abortions? We already know nationally that women of color have disparate childbirth outcomes when compared to their white counterparts. And that is across socioeconomic lines. And so I have been thinking a lot about these type of issues and how perhaps with the demise, and I'm calling it a temporary demise of Roe versus Wade, that opens the door to challenge our state governments to do something about these disparities, to better regulate the medical industry such that something should be done when you're seeing huge disparities based on race and socioeconomic status. I think that this could open the door for women to push for equal funding for medical research, for women's health care, for pregnancy care. So as much as I am in my feelings about the Roe versus Wade decision, I also feel like I am in my feelings about things that could not be addressed that affect women who look like me in particular. And of course, that connects me to a lot of that history and tradition surrounding the issue altogether. The failure to talk about our communities openly, right? When you read the Roe decision, you really get the sense that the court is only talking about sort of wealthier people in our history and tradition, not people who were poor, people who were enslaved, people who were dispossessed from their land. And so that's the spirit I see when I look at the future. And I should say I have the pleasure of teaching law students. I know some of what's important to them. They are very much in tune with this entire context, right? They want to see the type of racial justice in healthcare, and they see how an issue like this connects to that. And so for me, it's not so much that I am optimistic, I am determined because I come from a tradition where you have to be determined, right? To even be in the position I am in, someone several years ago had to see a world that no one else could exist or believe could exist. I have no choice but to see this future for women and everyone who wants to exercise their right to bodily autonomy.
Okay, thank you. We have lots of thank yous in the chat, but there are also some, still some questions. I think we have time for one more. Can you elaborate on the aid and abet part of this law? For example, say a family physician gives a pregnant patient the phone number for an out-of-state abortion provider. Are we still waiting for these things to be litigated to gain further clarity?
I think that's exactly what we're waiting on. I don't think that it is possible to really say how this law is going to apply. One, I think this is a law that was written that when it was written, nobody probably ever thought it would take effect, right? And two, it is unclear to me who is going to be, and I'm going to call them the unlucky prosecutor to bring charges. Four, we're at the very early stages of the litigation on this. And so what the scope, and that's what I wanted to emphasize with the Idaho Supreme Court decision, right? We've still got a whole trial potentially on how this law works and whether it is constitutional under Idaho's constitution. With regards to the federal lawsuit, we have a stay, right? But we've still got a whole trial ahead of us with regards to how does this apply for doctors, right? Is your medical judgment going to be protected? Are you going to go to jail for making medical decisions? Who is subjected to this law with regards to scope on questions like aiding and abetting? So a lot of this is just incredibly unclear. And let me say, as someone who teaches and writes in the area of the Constitution, who actually practiced in this area before I started teaching, this is kind of the part of the strategy, right? It's to create a confusing law, a law that's vague, right? Part of the strategy here is to make people afraid, to make people afraid to speak out and to exercise their rights. And so for me, some of this confusion is what is intended. And that's why I think it could be that these type of laws don't really have the effect that those who wrote them intended. And I should say that vagueness could be another fatal issue for this law, right? That it is just way too vague, that it doesn't make clear what's illegal and what's legal, right? The whole case could be decided on that as well.
All right, thank you so much. I see that we've got 1 minute. Let me see if there are any other questions. Lots and lots of thanks and compliments, saying it was an amazing presentation, and I agree with that. I don't think there are any more questions in here. I just want to say this is similar to the idea that a crisis presents opportunities, loads and loads of opportunities, and your optimism really speaks to that. So I really appreciate your optimism, and what a wonderful presentation. Thank you. Kylie, do you want to take over from here?
Sure. So I'll just echo all of the thanks to Professor Sanders. I also want to thank Zena and Henry Ann, who helped put this program together today. For next week, we are keeping on the legal topic. I will share my screen with a flyer for next week. This will be in person at the 1912 Center in Moscow at noon next Wednesday. And we are really lucky to have board member, speaker series committee member, and professor emeritus at the University of Idaho Law School, Don Burnett, joining us to give the talk next Wednesday. And this is an issue, if you have not heard about it yet, it will likely be on your radar soon, and that is the independent state legislature, fringe political theory or constitutional mandate. That will be in the auditorium a week from today, next Wednesday from noon to 1, and we're really looking forward to that.
All
That's
right.
everything that I have. So I'll go ahead and stop our recording, and thank you again, Professor Sanders, for joining us.